versus Gregory Allen Slate, attorney grievance number 5.
I'd like to address the court's questions concerning whether or not this opinion was published. I think to say that this opinion was published is an understatement. It was so publicly available that lay people who I encountered in any context in litigation would take the order and publish it into that case in an effort to persuade the court that I was a bad guy, or put this information in front of the court to gain an advantage. I apologize for not being clear. What I was trying to convey to the court with respect to the availability of the order was just with respect to what I believed. It was so available that it did not occur to me that it was possible that the character committee members weren't aware of it.
And one more question. Has Westlaw published the Howell opinion? Is that how people are finding it? Or
I believe the answer to that question is yes, Westlaw has published it. It was further published by various legal news
websites,
publications. So if you were to Google Greg Slate, is pretty much the first thing that you're going to see.
We don't normally do that.
I understand.
I want to be sure I understand what, for me at least, is somewhat central to all of this. You were aware, obviously, of Judge Howell's view of your actions and inactions during discovery and her findings. Were you counting on the D.C. Court of Appeals to have found them to be clearly erroneous? And at that stage, you thought it was, I mean, you tell me, is that what motivated you not to include information along that line in your application, is my question.
What motivated me not to include anything additional with the application was the instructions that I got from the State Board of Law Examiners while I was completing the
Which were essentially answer the questions, right?
Answer the questions, follow the directions, and I believe that Mr. Shipley testified at trial when asked if he had instructed me not to provide any other documents other than those called for, those asked and requested for by the bar application. I believe that his response was that he believed that that was part and parcel to what he had told me.
Well, insofar as those findings by Judge Howell speak of some dissembling and bad faith, you felt no compulsion to answer question 18 other than you did, which was no? I think you just answered no, didn't you? There's nothing else that would...
There was the supplement attached to the bar application when it was initially submitted. I should have answered that question yes, just by virtue of the fact of the girth of my litigation history and the volume of matters that I've been involved in before law school and during law school.
Well, the answer yes would have taken the character interview process down a different path altogether. You would acknowledge that now, I assume.
I believe now that it would have, yes. I'd also like to briefly address the 8.4 violation and the Attorney Grievance Commission's position that my statement in response to their letter that I had disclosed everything necessary and more was a knowing misrepresentation on my part. I do believe it is important for the court to consider that I was responding to a letter that was 14 pages, and it submitted that I hadn't disclosed a lot of things and just generally tried to provide as much detailed information about me as it could, and speculated that something must not have been disclosed. In the context of, it's also important to note that the record reflects and that the complainant concedes that there was a number of information in that letter that just wasn't accurate. There were assertions made that I was an affiliate, that I'd been involved in litigations in places and states that I'd never been. So in responding to a letter that had some misinformation in it and that didn't include all of the things that I'd actually disclosed on the bar application, failed to identify cases and matters that were clearly disclosed on the bar application, that was the sentiment behind the statement. I disclosed everything necessary and more, and I believed that I had, and I knew that I had disclosed more than the information that was in the complaint, and that was the motivation behind the statement. I never believed or conceived that the answer to what I disclosed on my bar application would come from ultimately me. The bar application speaks for itself, so I can't conceive of any motivation that I would have had to misrepresent that to the Attorney Grievance Commission. I was merely trying to respond to a voluminous complaint and cooperate with that investigation.
Do you want to address at all the sanction potentially?
I believe that under the factual findings of the court and the finding that my belief that I had sufficiently disclosed is actually an aggravating factor, that if this court believes that I intentionally didn't disclose this information and tried to withhold it, I don't think that I could stand here in front of the court today and say that I believe that any other sanction other than what AGC has suggested is appropriate. I think this is an all or nothing scenario. I either did it and I did it on purpose, and I did it because I was trying to conceal and gain an advantage, which I know wasn't the case. Or I did everything that I thought I was supposed to do. And that's the reality. I appreciate the court's time today.
All right. Thank you, Mr. Slate. Mr. Hine. Next up is number 37, Green versus State.